Let's see how many people are in. Got 66 coming in. Take more coming in. So give a couple of minutes and then we'll start. Okay, I think we should be able to start. I think 70 people has more or less come in, and okay. So once again, I welcome everyone to our webinar. We are actually running. Can I go? Sorry, can you go back to the previous slide, the first one? Yeah, sorry. Yeah. Okay, so basically, thanks for joining us once again on a webinar hosted by BAS. This time around, this is something very serious and obviously will impact everybody in this space, whether you are in purely the financial services or actually you are obviously in the digital assets business. So this is the Financial Services and Markets Bill 2022, right? Is essentially the one that everybody calls as the Omnibus Act, right? That covers a lot of things. So this time around, we are actually discussing this and the impact and what does it impact in, especially I think most of you are actually from cryptocurrency company or dealing with digital assets. We want to discuss the impact and implications beyond just cryptocurrency, but also digital assets, those that asset back as well, right? This is something that just came out, read out in Parliament. And of course, further details I think will be covered by our, as usual, our dear handsome ex-MAS officer, Mr. Nizam Ismail, right? He's going to be, I'm going to introduce you as such all the time from now on. And of course, our other colleagues from the BAS, Nizam is, again, I want to repeat, Nizam is the chair of the Regulatory and Compliance Subcommittee in Blockchain Association of Singapore. In this committee, we also have Yen Lee from McKinsey. We have also Pei Ying from Linklaters, and then we have Asman, right, from Upbeat. So myself, the secretary of the BS, as usual, will be your host or hosting for today to explain why we are doing this and the introduction. Now, how the format is going to be like is that, as usual, we are very open and very interactive, right? Whatever we gather is not something that we keep and then we forget it. The session is going to be recorded as well. We want to be, sharing this as a public application to everyone in the public. So please feel free to ask the questions. Now, I think there's a chat function as usual that you want to just give some comments by all means. But if there are certain questions that you want answered, right, please use the Q&A button, because then I think the panelists can look through and then we can answer online or type it out as well if we can, so that we capture every single question and don't miss out in the long chain of chat, because I think sometimes chat, everyone says something, sometimes is smiling at something and all that, right, but the question get lost. So use the Q&A to actually ask the questions and we answer based on that. The chat group, you can actually use it to, give some comments and all that. That's perfectly fine as well. We will also take note of that. So I think without further ado, let me hand over this to Nizam to kickstart this. Thank you. Over to you, Mr. Nizam.
Thank you, Kevin. And you must stop introducing me the way that you introduced me. But I think, very warm welcome. Good afternoon, everyone. Thanks for joining us in this webinar. We have a new bill, a new act that's going to impact the blockchain community. This time around, it's not a surprise because there was a previous consultation in August 2020. And you will recall we had a webinar at that point in time as well to take you through the proposals. We actually wrote a set of representations to the MAS at that point in time. I think some of them are considered by the MAS. Some of them were heard, but perhaps not adhered. I mean, not accepted. Not entirely surprisingly. Okay, so here we are. Just to give a sense of the legislative, process. So it has been brought for first reading in Singapore's Parliament. There is a second reading phase, and then it gets passed by Parliament, and there's a presidential assent, and then it becomes law. So assuming it becomes law maybe in a couple of months' time, it doesn't mean that it's implemented yet. So just remember that. There will be a process where the MAS might issue more regulations, more guidance to the Act, and then the implementation date will take place later on. Just as an analogy, when the PS Amendment Act was passed by Parliament in January of last year, is still not yet implemented, even though it's law. So this is we're going to be in a similar situation for the Act. So actually, we didn't call it the Omnibus Act. The MAS called it the Omnibus Act, Kevin, in the consultation paper. So, but they've given it a proper name, the Financial Services and Markets bill. So when it's passed by Parliament, it becomes the Act. So we will take you through the key provisions of the FSMB today. There would be impact on this community of people. Just to keep you updated as well, the last webinar we had was on the MES advertising and promotion circular. You will recall that. So that took the industry by surprise. So we actually, just to give you an update, we actually put in a set of written representations to the MES, which is now with them. It's being considered, we hope. And we look forward to a dialogue session with the MES on some of the our views on the advertising or promotions circular. Now, coming back to this, you might ask, why bother with a webinar when things are cooked in the oven already, when the bill has been passed? I think it's still important for us to understand the implication of this new law. There will be quite a bit of implication to this community. And also, if there are teething issues, or there's a lack of clarity, or there's some unintended consequences, I would like to think that we have an avenue of discussion or an audience with the MES to bring some of these concerns to the industry across. My gut feel is that there probably would be some issues like that, but we can. One of the things we want to do is to take you through some of these provisions, and you have comments or feedbacks. Please let us know, and we can take it back to the MES because we do have an ongoing dialogue, process with the MES to give them feedback from the industry. Okay, so we're going to make this interactive. So please feel free to jump in with your comments or thoughts. Please use the Q&A function. So similar to our panel members, Ian, Pei, and Azman, please feel free to jump in. So I'm going to take you through the first half of the presentation, and then Pei has very kindly offered to take you through the second half of it. So let's kick off. But as usual, we have a poll question just to get everybody participating and energized, and you exercise your fingers. So tell us about yourself. We want to know the audience we are talking to today, whether you're a DPT service provider, whether you are exempt, you're still waiting patiently, very, very patiently for your license, or whether maybe you're not licensed or exempt, but you're based here in Singapore. You could be the subject of the FSMB, or you are another financial institution, or others, right? You could be maybe just not a token issuer that's covered under 2, but anyone else. Thank you, poll mistress, for running the poll. So can you guys please cast your votes?
Okay, so I think everyone should be doing that right now. Let's see how the poll is like. Jiahui, is the poll up? Just now I already selected.
Yeah, the poll is up.
Yeah, is the poll is up, Jiahui?
Okay.
Okay, so I think we can see. Can see everyone?
Yes, we can see. So about a quarter, the very patient DPT service providers waiting for your license. Other VASPs, 12%. You are, my gut feel, you probably are very concerned about the impact of these bill on yourselves. Other FIs, 18%, and others, 47%. So that's a good mix for us. Okay, let's move on to the overview of the agenda today. So we're going to start with some key takeaways from the FSMB, just as an overview. And then we'll talk about the enhanced regulation of virtual asset service providers. Now these are the entities which are physically or incorporated in Singapore, but providing services outside of Singapore. So remember that is the main audience that the FSMB seeks to address. And next, I think Pei will take over from section 3 onwards. We'll talk about prohibition orders. That's the bit that could cause quite a bit of grief, I suspect. And 4 would be, some harmonized powers on technology risk management. And 5 is on statutory protection for individuals in dispute resolution schemes. Maybe 4 and 5 might be less of concern in terms of gravity to this group of people, but we'll still take you through them. Okay, let's move on. Okay, just a bit of an overview of the FSMB and how it sits in the whole scheme of things, if you like. So there is this MAS Act, right? So it is statutory powers being given to MAS as a statutory board, as a corporate entity. Remember, the MAS has got two broad functions. One is a central bank, and the other is a consolidated financial services regulator. So it's probably one of the very unique institutions that has both central bank and financial services regulator in one building. So the provisions relating to MAS supervisory powers are now taken out of the MAS Act and put in this FSMB. And the four areas in the box on the right-hand side, if Singapore VAS be conducting business outside of Singapore, prohibition orders, TRM, and statutory immunity, essentially for dispute resolution persons. So these are the new provisions that have been bolted on the FSMB. So the other bits of legislation that the MAS administers, the Banking Act, Insurance Act, SFA, FAA, Payment Services Act, I think most of you are familiar with that. So these remain, although some of the provisions relating to prohibition orders are now under this FSMB. So it's a little bit of a hybrid model, if you like. Let's move on. Okay, so some of the key takeaways. Now, the bill, one of the things it does is that it harmonizes certain provisions that apply across financial institutions classes, expands and consolidates existing regulatory powers to enhance MAS's agility and effectiveness in addressing risks. The provision of concern is virtual asset service providers that are created in Singapore. So whether you're a company or whether you're an individual or whether you're a partnership physically based in Singapore, but providing services outside of Singapore. So remember that. For the bulk of virtual asset service providers that provide services to persons in Singapore, the PSA or the PS Amendment Act, which is yet to be implemented, will apply. But we are talking about activities outside of Singapore. So next is on prohibition orders. So a prohibition order is, it's an exercise of an order effectively banning individuals or companies from participating in the financial sector. So it's like a red card. Off you go, you can't play in the game anymore. I think the issues on the prohibition orders, there are a few dimensions to it, right? So one, it expands the regime of POs, because previously it's only applicable to the SFA and the FAA and the IA, but now it applies across the board, including the Payment Services Act. So that's one. Two, it widens the instances in which a prohibition order can be issued, so long as somebody is not fit and proper. So it seems to have lowered the bar for which MAS can issue POs. So it's easier for the MAS to issue POs right now, so long as the person is not fit and proper. So we'll talk more about the qualifying criteria, if you like. Third, the other dimension is that prohibition orders can also be issued not just on the financial institution, but also on third-party service providers. And that seems to be a little bit broader than the original approach. Okay, so that's the PO regime. And what it means for financial institutions as well. When you engage a service provider, and you probably outsource lots of activities, whether it's technology, internal audit, compliance, marketing, or whatever it is, you now have to, as part of your due diligence process, make sure that your service providers are not subject to a prohibition order. So it does widen the expectations on financial institutions, okay? The other broad point on technology risk management is that not so much that it creates new expectations, so content-wise, it's probably neutral, but that there are new powers for the MAS to issue directions and impose a maximum penalty of $1 million. So it now gives teeth to the TRM expectations, right? And it's a real risk because, as you know, that with a lot of financial services being delivered digitally, the increased incidences of cyber attacks, phishing. Okay, we just had a very major incident a couple of weeks ago. So it's a very real risk, because there is a real risk that financial penalties can be imposed. So, and the last bit is on individuals in dispute resolution schemes. So we have a dispute resolution scheme called FIDREC, the Financial Institutions Dispute Resolution Scheme, which essentially provides an alternative dispute resolution mechanism separate from the courts, to allow retail investors very cheap and affordable and efficient means of resolving their disputes with financial institutions. So these provisions just gives the mediators, the adjudicators in the dispute resolution scheme statutory immunity. Okay, so let's move on to the first substantive area of discussion, which is the enhanced regulation of virtual asset service providers, or VASPs. Now, this is really, you might ask, why is this happening? The motivation for this, or the inspiration for this, is really the Financial Action Task Force, the FATF. For those of you who are new to this, this is the international body, the supranational body that sets anti-money laundering standards globally. So they are the ones pushing for things like the travel rule. And one of the requirements by the FATF is that they want to regulate various actors who are deemed to be virtual asset service providers. So that there is a list of activities that the FATF is interested in. And also in this instance, they want to mitigate the risk of regulatory arbitrage, where no single jurisdiction has sufficient regulatory hold over a specific VASP. What does this mean in layman terms, right? So you might have a situation where a crypto exchange, wants to set up in Singapore to enjoy, all the good things that come with a Singapore company, right? Reputation, rule of law, but mostly business reputation, right? But then taking the position that because I don't provide any services within Singapore, but my services are done outside of Singapore, I don't need a PSA license. So there's a bit of a regulatory arbitrage in that situation, because these entities might therefore not be regulated, because on the one hand, whilst they are based in Singapore, they're not licensed here. They will say they don't require to be licensed here, but they provide services to the rest of the world. So the question is, who has regulatory reach over such entities? So it's a bit interesting. Not really new. Why do I say not really new? Because under some of the other legislation, like the Securities and Futures Act, for instance, there is this whole section that talks about extraterritoriality of the SFA. And there are stipulated tests. So for instance, they're looking at things whether there is a substantial and reasonably foreseeable effect in Singapore, or if there are instances where some of the transactions happen in Singapore and outside of Singapore, the SFA still applies. But I think this is the MES being very specific in the realm of DT services. So what are DT services? DT services is a new concept. DT means digital tokens. It will capture two things. One is digital payments tokens, cryptos as we know it, utility tokens. So DPTs, remember, are tokens which can be used to pay for goods and services. So interestingly as well, just in the recent parliamentary debate, right, there was a question being asked of a certain Tharman Shanmugaratnam, who's the chairman of MES and the person who will never be prime minister. We are sorry to hear that. But the question was asked is, does the MES intend to regulate NFTs? The answer is no. So DT services doesn't include NFTs. So it includes cryptocurrencies or digital payment tokens or digital securities. So digital securities, remember, securities can be either shares or equity, or they can be debt instrument, or they can be collective investment scheme or funds. So they created this new concept. So if you provide certain services relating to digital tokens outside of Singapore, you need to be licensed. And this will cover whether individuals or partnerships from a place of business in Singapore, you're physically here, but you provide services outside of Singapore, or you have a Singapore company. And if you have a Singapore company, whether you provide the service from Singapore or elsewhere, you are still caught, right? So if you look at the box on the left, so digital token services, essentially cryptos and securities. So if done within Singapore, it would be caught under the PSA, the SFA. SFA would cover things like dealing, dealing in securities, or it will capture securities derivatives, or it will capture funds, it will capture markets or exchanges. Okay. Now the FAA would cover advisory services relating to securities or investment products, they call it, which includes securities. We also includes certain insurance products. So that's in Singapore. Now, outside of Singapore, where the service is done outside of Singapore, it will be governed under the FSMA or the FSMB at this stage. Okay. So everyone clear so far? So my fellow panel members, if you have any comments or interjections, please jump in.
If I may add something, Nizam, to this, in terms of the obviously wanting to enhance and align with the FedF regulated activities, I think we should also highlight the fact that MAS was also introduced those 5 regulated activities in the amendments of the PSA, which obviously will add on to the existing dealing and facilitating of DPTs under the PSA. So now we will also include in dealing with DPTs, safeguarding, administrating, and financial advice under the regulated activities. So I suppose, in part, together with this, they are trying to paper over some of the gaps that was existing between the FedF standards and the Singapore regulations.
Okay, let me just, I think, yeah, thanks so much for the prompt, Azman. So let me just skip to this, because I think this is the core of the discussion. You're absolutely spot on. I think things are getting a little bit more complicated, right? So just to recap, under the PSA, what's regulated for DPTs? One is dealing, buying or selling of cryptocurrencies, whether crypto to crypto or crypto to fiat, you're caught. 2 will be an exchange, a classical case of a crypto exchange, where you have multiple buyers and multiple sellers. There's a matching engine that matches these buys and sells. So that essentially is the function of an exchange. Everybody understands that. Now with the PS Amendment Act, it complicates things because there are additional activities relating to cryptos that would be regulated as well. One is crypto custody. There are provisions on, relating to, when you help move cryptos, or you help to broker or intermediate between buys and sells, even if you don't touch the crypto, you will need to be licensed under the PS Amendment Act. Remember, that's law, but it's not yet implemented. Now, this scope of activities that's before us today, in front of you right now, dealing in digital tokens, facilitating exchanges of digital tokens, inducing or attempting to induce any person to buy or sell digital tokens, accepting DTs for the purposes of transferring or transmitting DTs, safeguarding or administering. So that's a bit like custody, and financial advice relating to the offer and sale of DTs. I'll explain in a bit why financial is being italicized. So these activities are in relation of activities that take place outside of Singapore that would need to be licensed under the FSMB. What's interesting is advice relating to offer and sale of DTs. That would be one activity which is not found even under the PS Amendment Act. Now, why do I italicize the word financial? Under the explanatory brief, so this is the sort of summary issued by the MAS to explain how the FSMB works. Okay, it says financial advice relating to the offer and sale of DTs. However, in the actual bill itself, the word financial doesn't appear. So it's just providing advice relating to the offer and sale of DTs, whether in written form or otherwise, whether it's broadcasted. I mean, there's some other definitions, but it seems quite wide. And it could mean advice to a potential person who wants to buy, an investor who wants to buy cryptos, or it could also be interpreted to mean advice given to an issuer. So if somebody provides an advice to, let's say, a token issuer, that could technically require licensing, unless you fall within some of the exemptions. And some of the exemptions are things like technical service providers, for instance, mining, if you're into mining or you function as a validator node, or DT services provided in respect of CBDCs. They're not caught or services relating to a limited purpose digital payment tokens, right? This is within a closed ecosystem. You can't sell it, you can't convert it to other forms. There's a definition of limited purpose. So it's a little bit, it's a little bit anomalous because financial advice is not in the PSA or even the PS Amendment Act, but it is under the FSMB. Now, what this means is this, right? So if I provide advice, a service of providing advisory service to people to buy and sell cryptocurrencies in Singapore, that activity is not regulated. So it's not under the FAA because it's not in relation to investment product, because cryptos are not investment products under the FAA or SFA. However, if I were to provide this advice to persons outside of Singapore, I would need to be licensed under the the FSMB. So that's a little bit of an anomaly. So I'm going to pause here. Any thoughts by my panel members? Paying, you might have a view on this.
Thanks very much, Nizam. So what the MAS has been saying, I agree that it's a bit weird. And what they have been saying is that if you are providing advisory services, because remember, under the new legislation, a digital token includes two things. One is a digital representation of the capital markets product. So if you advise on a capital markets product, I think as Nizam said, security token, some other type of security or derivative, then you're already caught today under the Financial Advisors Act. But the reality is that there will be a second bucket, which is your digital payment token. So likes of Bitcoin, Ether, Ripple, etc. If you give advice on those, then you're not caught if you only advise Singapore clients from Singapore. But you have a bit of an odd situation where you then, if you provide services from Singapore to overseas clients, then that is caught. So I had another thought, which is I think one to watch out for. So as Nizam and Osman had said, the requirements and the scope of activities under the regulations in the Financial Services and Markets Bill is meant to align broadly with the PS Amendment Act, the Payment Services Amendment Act. So there's a bit of a question mark around, well, will the two legislations take effect at the same time? Because if they don't, then you have a bit of an awkward situation where, let's say you're providing custody, token custody services from Singapore, you don't need a license right now. And if the Financial Services and Markets Act then takes effect before the Payment Services Amendment Act, you're going to have to stop services that you're offering to overseas clients, because the Financial Services and Markets Act does not have a transition period. It's going to take effect immediately. So there's a bit of an awkward situation. One would hope that the two legislation would take effect at the same time.
Yeah, we're speculating. I think we had an internal chat whether that was part of the reason that the implementation of the PS Amendment Act was put on hold because of this impending FSMB that's coming up. We don't know, but it seems sensible to get them implemented together, I think. Yeah, there are a couple of questions from the audience. One is, if an individual buys and sells cryptos on behalf of another individual without advice, whether that's caught under the FSMB. Anybody wants to take this? Ping, I'm looking at you virtually.
To buy crypto on behalf.
Yeah, I'm sorry, I didn't get that. Is it in the panel?
It's in the FAQ, yes. So if I buy or sell cryptos on behalf of someone else, but there's no advice given, would I need to be licensed under the FSMB?
Yeah, I suppose so, because it's buying and selling, right? It should be caught today if you're doing it for Singapore persons.
Yeah, I think under the PSA it was clearly written that if you're a broker, because in this case it constitutes as a broker because you're buying on behalf of somebody, right? So I think that's been actually mentioned numerous times, numerous graphics that MAS publishes. If you're brokering a deal, even though you're not keeping the tokens, right, you are actually supposed to be licensed under the PSA. So I think this probably covers that. Yeah.
What if it's just a one-off and not run as a business?
I think that time it was actually okay. So basically, we want to look at it as a one-off, right?
Yeah.
So that's the case of the girl who got arrested for trying to sell off the Bitcoin, for on behalf of somebody else, right? To help to facilitate that. So if you're going to use that as a precedent case, then obviously that's a one-off as well. But she got arrested, so I think it's the probably going to be applied similarly as well.
I think a lot depends on the facts and circumstances for the one-off instance, right? I mean, someone told me that the universal answer to any question is it depends on the facts and circumstances of the case, and I think it applies in this case as well. It's a legal issue whether a one-off transaction is deemed to be the business of doing something that's a regulated activity.
Yeah.
Technically, it can be, but I think it depends on a whole variety of things. So, for instance, if a father sells it on behalf of the daughter, maybe you can argue it's not a business. But then again, let's not get into that. There's another question that's asked if there's a Singapore holdco that has a few overseas subsidiaries. So one of which issues DPTs and another which sells DPTs, would it be caught under the bill and require licensing?
Shell holdco of a few.
So there's a holdco, but it's a subsidiary that buys and sells DPTs outside of Singapore. So technically, it's not a Singapore company; it's a Singapore holdco.
Yeah, and the operating entities are out. It wasn't created in Singapore, and it's also so. I don't think it's caught under this FSM bill, unless you can say that the profits and losses of the buying and selling is, are consolidated at the holdco level.
Yeah, I suppose that's a view.
Yeah.
Would you agree with that?
Yeah, I think so. I think it depends on what this whole call is doing. Whether it does nothing, and then if it does nothing, you would say it's not carrying on a digital token service from Singapore. It's merely a whole call. But if it actually gets involved in buying and selling, I think as Afman said, if for some reason it gets booked back to the whole call, then there's a question mark around whether it could be viewed as a counterparty and therefore caught.
I think there was a comment by Bill that BTC is not security. Yes, it's not security, but remember digital tokens also include cryptos. So digital tokens, and maybe I'll move to this slide. We skip around a little bit. I'm having some issues with my Zoom. So it includes digital payment tokens, so cryptocurrencies, or digital representation of securities, right? So it will be caught. There are a couple of other considerations on certain activities. Some of these were addressed by the MAS in the response to the consultation paper. So please read the document. So you got to look out for the consultation paper on the Omnibus Act. And then there is a section that talks about responses by the MAS. Please read that response document because it articulates MAS's policy thinking. So some of the detailed exposition on why they accepted certain recommendations or certain feedback or not is all in there. So there are a couple of scenarios, I think, on the Application Act. One is the guys who market ICO tokens overseas. Chances are you would probably be caught under the FSMB, I think, because that's providing advice on digital tokens. And then there's a provision of financial advisory services related to DTs that are capital markets products. So if they are capital markets products, they're already caught under the Securities and Futures Act. You probably already need licensing. So if you give financial advisory services on digital securities or digital funds or ETFs, so those are all capital markets products. They are already under the SFA. And then service providers that provides advice on the issuance of DTs. So they are caught under the FSMB. So this is like we discussed earlier on. So this is anomalous because this is only applicable regulated if the advice is given outside of Singapore, but within Singapore, if it's just cryptos, if it's just purely cryptos, then it's not caught under the FAA. So MAS also talked about fund management with DTs as underlying that these are likely to be regulated under the SFA, right? So let me just go back to where we were. So we discussed this and this. Okay, so what does it mean? What does it mean that if you are caught under the FSMB? So, I mean, these are the basic requirements for any licensing, similar to the PSA licensing requirements. You need to be incorporated in Singapore. You must at least as one executive director. There are financial requirements. So the MS did say they will consult on the 250,000 base capital requirements, which is the requirement that currently applies to major payment institutions. AML, of course, is front and center. So there's PSNO2, that's the notice that's applicable for crypto guys. And then it needs to be a compliance function. We'll talk about more about that in a bit. And then compliance with technology risk management and cyber hygiene requirements, and record keeping obligations, which are standard across the board. There is also a prohibition from carrying on certain businesses, which is lending or providing any credit facility to any person in Singapore. So even for PSA license holders, you can't do that within the entity. So, if you want to do lending, it has to be in an unregulated entity. Okay. There are a couple more questions that came in. Maybe we can address that. One, would a company that is providing a DeFi, decentralized finance platform, allowing the users to stake or swap crypto, will that be caught? Does anybody want to take that question? Anyone?
I can take a crack at it. So I think if we look at the current framework, it's not clear whether it'll be caught. However, if we follow the MAS explanatory note that says that the FSB is to align it with what FATF intends to do, then it may indicate that DeFi platforms will require licensing. After all, in the recent FATF guidelines, they did say that they intended to capture DeFi, but as to how they intended to do it, there was guidance around, perhaps either targeting the developers or the project owners. So at least under the FATF documentation, the explanation as to how they might approach it has been made very clear. Inside MAS's approach, they did not. So it remains to be seen whether or not MAS will take that same approach and apply it to, let's say, inducing and attempting to induce, or perhaps under a safeguarding and administration. After all, some of the DeFi platforms, the way that the smart contract works is that the funds are stored inside a smart contract, right, which can then be argued that there is custody involved by the project owners. Yeah. But that's my personal opinion. I think we'll have to wait for MAS to provide a little bit more guidance there.
Yeah, just to complicate things a little bit, I think if there's element of custody that's involved, the PS Amendment Act could potentially apply, and even the FSMB. Paying, do you have a view on this?
Yeah, I think that's right. So potentially the in relation to custody, they would both apply.
Okay, there's another question. Sorry, Kevin, did you want to say something?
Yeah, I'm just saying that, just to add on to what Ping was saying, right? Because the whole idea about staking is actually custody. Because the moment you stake your tokens there, you're actually in custody, and that covers under the, and based on my conversation with the MS officer this morning, that is actually heavily looked into right now. So I think previously DeFi was not such a big thing with a lot of projects, even for the PSA entities, but DeFi is now a big thing for even for most of the PSA entities as well. Including the new applicants, right? So this is actually heavily looked into under the Payment Services Act amendment, right? Which includes the serious view of custody, and DeFi happens to be function with this whole entire staking mechanism is actually custody. So I think this is going to be heavily looked into, and will definitely and based on whichever, the conversation, it is definitely going to be regulated under the Payment Services Act. Plus the fact that the tokens itself may function as a payment token as well. So I think that is really no way to actually run from this. Yeah.
I just want to throw a little bit of a spanner in the works on that. I mean, if they were to just try and regulate DeFi under custody, I think they're missing the point, because clearly DeFi has a lot more features and functionalities than just custody and safekeeping of the asset. I mean, clearly it goes into areas of capital markets product in terms of portfolio allocation, investments, lending, and there are other various aspects of it. So I mean, I'm looking at obviously the FedF. I mean, clearly under the FedF, they said operators of such a platform and also the owners of the platform are responsible to ensure that they have KYC, AML, and of course the transaction monitoring to mitigate against those type of risks. So I think if only they were to utilize custody in this respect to regulate a DeFi platform, I think, you know, clearly this, and I think MAS to make further changes in relation to DeFi together with stable coins in the application of and to be consistent with FedF regulations. These are just my thoughts. I mean, I agree with there's still uncertainty around the current regulation as they propose, but I think that we can expect a lot more from MAS from this.
Yeah, I guess this also drags on to quite a fair bit of, you know, by extension, as what Nizam probably covered in terms of the ICO advisories, the marketers, and now obviously getting very popular are all the IDO launchpads and all the various launchpad platforms and all that support such projects to obviously do fundraising and all that as well, which then puts such platforms, which some of them operates in Singapore, some overseas, but they are registered in Singapore, that covers under this act, because I think under the Omnibus Act itself, it states very clearly, prohibition order can be on a third-party service provider. So that includes all these various, you know, advisories or launchpads that are not directly running the project, but they are the ones supporting the project. So I think they could be impacted quite badly in this as well.
Yeah, I think I would just add, so echo what Asman has said just now about, you know, it depends on what activity you're conducting, because the MES has always said they're technology neutral, they focus on the activity that you're doing. So no DeFi platform is going to be exactly the same. And potentially there are a few new regulated activities that could capture them. I mean, apart from custody, you could also be viewed as inducing someone to buy and sell DPT. You could also be viewed as facilitating the transfer of DPT if you move DPTs from one wallet to another. So again, you need to look at what exactly the platform is doing and then work out under what activities it would be caught.
Right. There's an interesting question from the audience on the Q&A panel. I think probably answer that first, because I think Nizam has mentioned it quite a few times previously and now as well in previous webinar and now, that NFT is actually not exactly regulated. I think that comes from Mr. Taman himself. But that being said, this question is very relevant, and this is something that I've always been talking about. Now, there are strict, clear NFT sales that the NFT sales you sell it and all that. You know, obviously that doesn't cover that. But then there are NFTs that has a staking mechanism. It comes with its own token, which is probably a digital payment token itself, and has staking capabilities for those tokens. So the question is that I think someone is asking, will then now that the NFT marketplace considered as a custody and then therefore regulated? So maybe we can you know, probably answer the question. Someone, maybe Nizam, since you mentioned before NFT is definitely not regulated. Like in this case, would it be regulated?
I think you got to separate the two. I mean, there are a few activities, right? The NFT marketplace in itself is not regulated, so that's clear. But if you have a staking mechanism, it goes back to the discussion we had, that it's analyzed separately, and then you have to look at the structure, whether it potentially, you know, could be a collective investment scheme, or whether it could involve custody, or as Ping mentioned, whether it could involve you know, facilitating the movement of digital tokens. So we have to break down the different activities. But it's clear, I think, not just in terms of what Taman said in Parliament, but also in the response document by the MAS. It makes it clear that they are not regulating digital representation of physical products. So there was a question on commodities, or I think it wasn't explicit, but I think the question was on NFTs as well. So it's not meant to capture digital commodities or digital representations of physical products. So it's very clear, we're talking really about the DPTs and securities. The other question that was also quite interesting on research reports. So what about things like Bloomberg financial you know, reporting, Morningstar social media posts? If you have a blog on digital tokens, are you going to be caught under the FSMB? I think it's very interesting because under the Financial Advisors Act, so if you're talking about securities, there are certain exemptions for electronic publications, or, you know, like Bloomberg. And I think, but interestingly, under the FSMB, I don't see a similar exemption for publications. Correct me if I'm wrong. So this might be a little bit unclear. Anybody wants to comment on that? Anybody has any thoughts? Okay, let's just park this. I think it's worth taking a closer look. But from my recollection, it seems to be unclear.
And also, Niza, I just wanted to add a little bit more on that, because obviously there is a prohibition against marketing. And remember when we had those discussion, how far and wide that sort of marketing and promotion, does it go into things like media and things like that? So it's also depend on the content of the articles and the way it's being pushed forward or promoted, right? So I think that's also another consideration that we have to take into account, and not just from the advisory side of things.
Yeah, absolutely. So I think, so even in the traditional securities world, if somebody reports on a company and you stop short of making any advice or giving any advice on where to buy, sell, or hold, arguably that might not be deemed to be a regulated activity. So you're right, Azman. I think it depends on the content or the approach taken in that online publication. Let's just move on, because we still have some bits to cover. Okay, so we spoke a little earlier on about anti-money laundering, because you know, the regulators think that cryptos have got you know, a more focus or sharper money laundering risk because of the pseudonymity, the ease of transfer across borders, etc., etc. Although I think not enough is still being said about the mitigants of anything that's on the blockchain, because you could, you know, it's a permanent audit trail, right? So you must not be very bright to want to launder monies on the crypto, unless Ian disagrees with me. Ian, you don't disagree with me?
Sorry, I was replying to somebody inside the chat with regards to the report. Yeah. No, I don't disagree.
I think in terms of the risk, Nizam, is the fact that we are seeing an increasing amount of scams and fraud that's being perpetrated on the online. I think it's more the fact that a lot of these transactions are non-face-to-face, right? You are not able to positively identify who the other party is on the other side, whether or not they are assuming somebody's profile or you know, identity. You know, that's still a question that remains. I think it's an elephant in the room that is still not being fully discussed. Whether or not the high risk is alluded more towards that, rather than, you know, or the scam that follows, rather than the fact that we are dealing with cryptos, which is essentially the volatility of the cryptos themselves, which is a price thing, and there's an investment decision, rather than the fact that you're entering into a transaction which with someone you do not know whether it's impersonating someone else.
Yep, fair points, Asman. Thanks for that. I think it'll be nice if someday the regulators can also acknowledge that, you know, there are inherent traits of the blockchain that you know, makes it you know, quite stupid as for people to want to launder.
I think it would be helpful if they specifically identify the risk, rather than say that because it's pseudonymous, it's speed, efficiency, cross-border, therefore it's high risk. You know, and then they tie it with a lot of scam that happens. But those scams are as a result of the fact that impersonation risk and things that, which is nothing to do with blockchain, right? So, you know, so some of this, I think with time, I hope to see a lot more clarity in terms of identifying of the specific risks and how best to mitigate against them. Yeah,
unfortunately, scams happen all the time, right? So even in the non-crypto world,
absolutely.
Yeah, the recent scams in Singapore, everybody knows, doesn't involve crypto; it involves a bank.
Yes,
but we don't ban fiat currency because of that, right? Or we don't ban digital banking because of that. Okay, but anyway, coming to the compliance requirements. So as you know, as with most licensed entities, you must have a compliance function. So it could be an independent compliance function here in Singapore, or you could get support from the holding company. Although from my experience, the MES doesn't always like that to happen. Or you could appoint a qualified compliance officer based in Singapore at the management level. And the MES did say that it would consult on the form of the compliance function. going forward. So let's move on. Okay, let's, yeah, I know there's some more questions. We will take those as well, but let's just do a poll at this point in time. How do you guys feel about the VASP provisions in the FSMB? Do you think it's necessary? Is appropriate regulation is required? Or do you think that this is over-regulation and it's unnecessary? What are your thoughts? The poll is up, so let's hear your thoughts.
Seems at this moment in time, majority, at least, well, not overwhelming majority, but a good majority believes that it's necessary. Regulation is quite surprised.
There's no surprise there. It's a question of clarity.
Yeah, possibly. But, well, at least I guess that the folks attending the sessions today are looking for a bit of balance versus probably potentially some who are obviously totally against the regulations. But I guess attendees were probably looking for clarity in this, so they probably would have really supported regulation. So I think let's end the poll. 65% says it's necessary, and 35% says over regulation.
Fair enough. There are a couple of Q&A questions as well.
Yeah, let's go to that.
Which one shall we? Okay, the first is, can a Singapore bank set up an omnibus account with an overseas VASP, a crypto bank, for their clients? Do they need a new license, or they can rely on Circular CMI 26/2019 in just notifying the MES? This sounds like someone who works in a bank. Anybody wants to take that?
Not sure what is CMI 26/2019. That's the thing, the circular.
Yeah, I don't know. Let's get back to that, because I don't know what the answer is. So it's quite technical, but yeah, we will get to that. Okay. Next one, for local licensed VASP in Singapore, does dealing in DT needs to be traded and booked in Singapore? Can it be traded and booked overseas, like the private banking global model? I think that's quite a separate issue from the FSMB, right? First of all, if you're licensed in Singapore, then you don't have to worry about largely you don't have to worry about the FSMB. And then the booking is more a commercial decision or business decision rather. It doesn't make it fall within the FSMB bucket, I think, because that's booking. Yeah, unless somebody else of the panel members have got a different view on that. Okay, next one is interesting. How about influencers on YouTube or TikTok? I added a TikTok bit, who highlight or educate people on cryptos. Will they be caught under the advisor limb? Any takers on that?
Well, influencers are definitely caught under that marketing ban. So the question of whether it extends to advice as well can be considered advice. Then it depends on whether financial advice, or they just limit it to, or they're going to expand it to something else beyond financial advice.
I'm not so sure about the marketing bit. I think it depends on what the person does, right? I mean, if it's...
No, but I think the ban clearly says third-party influencers as well. If you're promoting your
Oh, sorry, the advertising and circular,
yeah,
promotion circular. Yeah, you're right.
It covers that. So now the question of the advisory limb, whether the financial advice extend beyond just financial advice, or it's just pure advice. I mean, the distinction between two, and that's something we don't know until we get clarity from MAS, I assume.
Yeah. Okay. Let's move on. Next one. A few questions. So this is great. Can you comment on the ANA blockchain scam that was on the news early this week? Anybody wants to take that?
ANA.
I mean, the AA scam was pretty straightforward. Basically, it was a scam trying to promote a mining investment scheme. So I wouldn't say there's anything too much to comment on it. It's pretty common, and we see many similar types. So not sure if there was something specific that the audience wanted to know about that scam. Okay, but it has been posted on the SPF website, and the public has been warned to lodge a police report to anybody who's involved in it.
Are the operators here in Singapore, or it's outside? Presumably it's outside, right, Ian?
They are actually in Singapore. They have an office. They are registered directors that are Yeah, so they have the mostly Chinese nationals, I would say. So
Very brave.
yeah.
Then.
Okay, let's move on. Is it mandatory for an independent audit on AML KYC processes and in place? Not all have internal audit functions. Well, if you're applying for a license under the PSA, you need to have an internal audit function.
You can outsource it.
Yeah, you can outsource it. I'm not sure whether it's, I think a lot of the details on the licensing requirements might not be out yet. Typically, there will be in regulations or there'll be some guidelines on licensing. My gut feel, probably you need to have that, but let's wait for the MES to officially notify us on that. So
No, I think probably as an experience to share, right? I mean, most of the time in talking to the case officer, they would say that it's a good thing to have your own internal audit function. I mean, again, it can be outsourced party as long as it's stated clearly, but need to have an internal audit function plus also obviously an external one just to audit over things. But yeah, it's needed. Seems like that was a question raised in all the applications, kind of.
Yeah, definitely for the PSA, you need to identify who your internal audit function or person is. Similarly for the SFA applications as well. But I think it will be applicable, but let's just wait for that. The next question, I think, on money heists from the Bangladeshi Central Bank. I think we want to focus on the issues of this webinar. Sorry, we're not going to answer that. Any enhancement on banking relationship for DT and crypto startups, will it be more banking friendly? I think everybody on the panel would empathize with you. We think the answer should be yes. Anecdotally, we think things are getting a little bit better. It's still very painful. It's still a very painful process, but they're not shutting the windows automatically as they did previously. But there's plenty of room for improvement, and I hope things improve, but it's not ideal at this point in time. That's my sense of it. Okay, next question. What about a non-fintech legal entity registered in Singapore with subsidiaries open in other regional markets which want to tokenize its assets and sell them to the general public? So the DTs will represent shares in that asset, which will continue to generate profit, and therefore a portion of the profit to be distributed to the token holders. It sounds like a securities token.
Yeah.
People agree with that?
Yes. And even if it's not securities, also considered a token issuance, right? So they will be covered and captured under licensing requirement. So
well, the thing about non-securities tokens, I think when we had a webinar between the BAS and the MES, I think I asked that question. So for ICO tokens, would that be regulated under the PSA? I think the response for the MES was technically yes, but if it's a one-off issuance, you might want to get legal advice with it as a business of dealing in DPTs. So that was, I think, as much clarity as we ever got from the MES. I don't know whether, paying, how would you advise an ICO, a client of yours?
I'm curious, somewhere, how can it be a one-off for a token issuer under DPT? In what scenario can it be just a one-off?
Technically, it can be. I can issue a token, and then after that, it gets listed. But I'm not issuing it because it's listed on a third-party exchange.
So just one time you issue and you don't issue anymore. No secondary, no tranches.
Yeah, theoretically, it's possible. I don't know. Okay. What are your thoughts? I mean, anyway, paying, you must have had experience in this.
Yeah. We've had the MES said that if it's one-off, then potentially it's not a business. But again, the question is, how practical is it to run a business if you only do it once? Because if you do it a second time, then I think they are quite likely to view it as a business already. So I think that's the question. That's the point. As for this specific question that's being asked, so I think the analysis can be quite complicated depending on how you structure the underlying asset. For example, it could be a collective investment scheme, or it could be some type of derivative. So you need to have a look at how you're structuring it. But it does sound like it's likely going to be caught under some type of legislation.
Yeah, thanks for that. Let's move on. I think we still have some grounds to cover on prohibition orders. So, let me just, so this is the requirement of permanent place of business, which is one of the licensing requirements. So it essentially means you need to have a fixed location and, a segregated space where records of transactions can either be stored or accessed. So essentially you need an own office space for a license holder. So we now reached the bit about prohibition orders. So I now hand you over to Pei, who will take you through these slides.
Yeah, thanks very much, Nizam. So we are now at the topic of prohibition orders. So as background purposes for everyone here, the MES currently issues prohibition orders, or we call them POs, to prevent persons that they regard as unsuitable from conducting certain activities or in holding key roles in financial institutions. So the current position is that the MES has found that their hands are a bit tied because they only have statutory powers in specific legislation. So in the Securities and Futures Act, and the Financial Advisors Act, and the Insurance Act. So practically what this means is that if someone has breached, for example, the Banking Act and has committed serious misconduct, then the current regime doesn't permit for prohibition orders to be issued under the Banking Act, for example. So what the regulator has then done is that they thought, well, we need to have a streamlined approach. I want to have the sector-wide powers to issue prohibition orders to persons who have some kind of nexus with the Singapore financial services sector. So broadly speaking, as you see on this slide, three key changes. The first is they will broaden the scope of persons who may become subject to POs. They will widen the activities that are subject to POs. And thirdly, they have decided to rationalize and streamline the grounds for issuing POs. They're going to apply a single fit and proper test. So we'll go through some of the details over the next slides. So over the slide, please. Over the slide, please. Yeah, so before we go into the details, let us have a look at the effect of a PO. So what happens if a person is issued with a PO? It means that that particular person cannot conduct MES regulated activities, cannot hold key roles, and as you will see in later slides, they cannot conduct certain functions, including service providers. So that's the first effect. The second effect is that for financial institutions who hire prohibited persons, it is actually an offense. And the third practical effect is that this means that going forward, financial institutions will need to check that their own employees, as well as their service providers' employees, have not been issued with a PO. So there's a question around, well, how am I going to check? Will prohibition orders be published? The answer is yes. The MES said that all POs will be published, and they will put them on a specific dedicated enforcement actions page, and it will be on NESnet for 5 years or earlier if the PO stops being enforced. If the particular individual is also a registered representative under the Securities and Futures Act and Financial Advisors Act, there is currently a public register for such individuals, and this will also be reflected on that register if that person has a prohibition order issued against them. And thirdly, just to let you know, going forward, if you want to obtain records of POs that are previously issued but perhaps have expired and are no longer available on the public website, you can do that. You need to pay a fee to the MES. So over the slide, please. So this slide just tells you that there are some checks and balances that the MES has implemented, because they had a lot of industry feedback that, well, this is really broad, you know, what does it all mean? Now anyone can potentially be caught. So they then said, oh, let's just take a step back and look at what the purpose of the PO is really to protect the financial industry and customers and investors against persons who have demonstrated that they are unsuitable to take up roles, activities, or functions in the financial industry. So with that in mind, the MES also recognizes that, you know, POs can quite seriously affect somebody's livelihood. So they said they will use these powers in a risk proportionate manner. And just to let you know, the MES has a wide range of enforcement action tools that they can apply. So for example, they can issue a private warning. They can also issue, just a slight slap on the wrist. It may just be a verbal warning, maybe a written warning. It may be some kind of formal disciplinary action. It doesn't need to go straight to a prohibition order. So the MES has said they will calibrate their action to be taken based on the circumstances, such as how serious the misconduct is, what type of misconduct is it, how exactly is the financial sector going to be harmed, and also how long has it been since the misconduct. And they kind of reassured the industry to say that we will only issue POs only in cases of serious misconduct. And the last point to note here also is that the MES's powers will continue to be subject to existing checks and balances. So what does that mean? It means that if a person is issued with a PO, or indeed, they've been given notice that the POs are going to be issued soon, the MES needs to give them an opportunity to make representations before the POs are formally issued. And after the PO has been issued, the MES needs to give the person a right to appeal against the MES's decision. So we had a quick look at the past enforcement records. The good news is that there is precedent of successful appeals. So in March 2019, there was an appeal where someone had petitioned the minister in charge of the MES and got their PO issued. It was 2 years. They got it shortened to 1 year. So that is good news. It's a bit vague as to why the person had a PO issued. It was on the grounds that they had not honestly carried out their duties to their clients, and that their performance as an appointed rep was unsatisfactory. But nevertheless, some good news that it could be shortened if you appeal successfully. So over the slide, just to do a recap of what exactly is changing. So currently, as I mentioned, MES's powers reside in certain legislation. Their hands are tied for other legislation. This will change going forward. It's going to be a sector-wide enforcement power that they will have under the new FSMB. So over the slide, going into some of the details of the grounds of issuing a PO. So at the moment, because their powers are only set out in certain legislation, the criteria that needs to exist before the MES may issue a PO is quite narrow. It's very specific. So for example, under the Securities and Futures Act, only the MES has either suspended or revoked your license, or otherwise revoke the registration or suspended an individual as an appointed representative. So again, quite serious. Or another ground would be if the MES has reason to believe that this particular person has breached the law or breached the Securities and Futures Act, or likely will breach the Securities and Futures Act. So quite a narrow set of circumstances. And going forward under the new legislation, what will change is that all of these will be replaced with a single test, and that's the fitness and properness test, the fit and proper test, where you look at 3 key things: honesty and integrity and reputation, competence and capability, and financial soundness. So there's a question here around whether we think this kind of test is quite broad, because it may not necessarily be limited to only serious misconduct. Does the panel have any views that you want to share?
I think maybe just to do a bit of recap, right? So the fit and proper guidelines are, it's a very lengthy set of guidelines that talks about instances which could give rise to fit and proper issues. So when we had the discussion on the consultation paper, I think this was one of the issues that we raised. Because for instance, under the fit and proper guidelines, so even if there's a complaint that's been made against you, and this is at the complaint stage, even regardless of the outcome of the complaint, that will be a red flag. Or is somebody has been disciplined or censured, so even if it's or warned, you have to disclose all that under the fit and proper guidelines. So there were things which were not yet determined, but could still give rise to fit and proper issues. So we gave the comment previously that we think it's too wide. The fit and proper guidelines was too wide to be a ground for issuing the PO, because under the SFA, is only for the more serious offenses. So there could be a regulatory breach that is not major, but doesn't give rise to a PO. So it's only for a very bad instance like insider trading or market rigging, or and of course, in relation to 1MDB, there were some unprecedented POs being issued. So that was the feedback was given. But I think the MES's response was they will look at things holistically, and there's an opportunity to be heard, and there's a right of appeal to the minister. From my own personal experience, we have succeeded in getting a PO reduced. So it is possible to get it reduced, although it's a very painful process to do that. But the rest of the panel members, your thoughts on this? Anyone? I think we can move along then, Pei.
Yeah, okay, sure, happy to. Okay, let's head over to the next slide. So the question then here is, what about the scope of persons who can be caught? Like, is it only your director, shareholder, for example? So just to recap, the current position is that the MES can prevent unsuitable persons from taking up directorships, substantial shareholdings. They cannot become a substantial shareholder, and also they cannot manage and conduct regulated activities under the 3 sets of legislation that I mentioned just now. Under the new legislation, the MES has widened the scope of prohibition. And this is the bit where you see on the right-hand side, they have decided to add a few additional functions. And in the MES's view, these are critical to the integrity and functioning of a financial institution. So you're looking at people who handle funds, including those who provide custody, so safeguarding or administering DPTs or DPT instruments. You have people who do risk-taking, so for example, the traders. And then you have risk management and control. So this is very broad, includes AML, CFT functions, includes audit functions, for example, and also critical system administration. And then the last bit where they said any other function which MES may prescribe. So this was their previous proposal. So the industry thought it was very broad. So they kind of said, do we need to kind of apply conditions to this, any other function that you can prescribe? So the MES took in the industry feedback. They limited it by adding the words that these functions must be critical to the integrity and functioning of the FIs. And they also assured the industry that before they add on new functions by way of regulations, they will engage the industry and give institutions adequate time to implement new measures or new controls. So the interesting thing here is that there has been industry feedback, including BAS, that has been given to MES. In fact, it was a majority of feedback to say that we can understand if you want to prevent people who are very senior, so let's say chief financial officer, chief risk officer, from and you want to capture these people in your new additional functions. But is it quite broad to also extend it to say someone who's quite junior in risk management, as an example? And then the suggestion given by quite a lot of people in the industry to the MES was, how about you align this to the MES's individual accountability and conduct regime? So just to let you know, that regime is live today, and that regime captures people who are regarded as senior managers or material risk personnel. So the MES received the feedback and they did not agree. They said that even if you have individuals who do not fall within these categories, so basically people who are not managers, for example, they can still cause significant harm to customers or FIs if they perform any of these 4 additional functions. To help with implementation, MES said they will provide in due course, in a set of guidelines, a non-exhaustive list of the types of roles that would fall within each function. So I'm going to open it up to the panel and see if anyone else has any comments.
Yeah, we did give quite a bit of feedback on this. I think in relation to risk management, for instance, typically, it's done collectively. It's not one person making a risk decision. But unfortunately, the position that MES has taken is what it is. So,
yeah, okay. Anybody else? If not, we can move on. Okay. So just over the slide, just to highlight the categories of persons that can be subject to the POs. The legislation actually says that the MES can issue a PO to any person. That's it. But in their response to industry feedback, they clarified that well, it can't just be any persons whatsoever. They said that that person needs to have some kind of nexus to the Singapore financial services sector. So here you will see that it can include persons overseas and such as service providers. It can include persons with outside of core management functions, outside of being a senior manager, outside of a material risk personnel, regardless of how senior they are. But nevertheless, they will have to have some kind of nexus to the Singapore financial industry. So over the slide, this has some implications on outsourcing arrangements. Oh,
So,
hang on. We have a poll.
okay, let's do the poll first.
So, yeah.
So, how do you feel about the PO provisions? Whether it's necessary and appropriate, it's necessary but a bit wide, or it's unnecessary, it's over-regulation? So it's news, but remember that it could apply to any licensed entity under the PSA or under the FSMB. Kevin, can we complete the poll? Okay, I think it's interesting. So most people feel it's necessary but overly wide. That seems to be aligned with our thinking. Unfortunately, it is what it is. So maybe Paying, you wanna?
Yeah, sure. Okay, so this one is just to highlight, that this means there's some implications for your outsourcing arrangements. The key point is to note is that going forward, when you enter into outsourcing arrangements with your service providers, for the additional functions that we described just now, or with respect to regulated activity, then you need to make sure that the service provider and their employees are not actually subject to any prohibition order. There is a defense. So if you have done your own checks, for example, you've gone to the enforcement website, you've checked whether the person's names have appeared there. So if you've done some checks and you could explain to the MAS that you've taken reasonable steps to ensure compliance, then there's a defense and you wouldn't be regarded as being liable under the legislation. So over the slide. So I think we can move on now to TRM, unless there are any kind of final words on prohibition orders from the panel. Okay, let's move on to technology risk management. So in this section, it's really the MAS recognizing that financial institutions are highly reliant on technology to deliver services. And the MAS feels that as Singapore continues to be a smart financial center, there is a need to ensure safety and soundness of the system that support delivery of financial services. And they feel that's key to maintaining confidence in our financial sector. So over the slide, if you look at the harmonized powers under the legislation. So the current approach at the moment is that the MAS has issued guidance in the form of a notice and a set of guidelines under specific legislation to financial institutions. So for example, there is a notice 644 for banks, an equivalent version for capital market services licensees. So the notice is legally binding and the guidelines are not, but they provide best practices guidance that you're expected to comply with. The notices broadly focus on the need to comply with tech risk management requirements for your critical systems. So only systems that would, if it fails, will cause significant disruption to your operations or otherwise materially affect the services that you provide to your customers as a financial institution. So broadly speaking, significant systems. So the MAS has said they want to change all this under the new Financial Services and Markets Bill. So what exactly is changing? I say three key things just to highlight to you. The first is that there will be a new consolidated centralized power for the MAS to issue directions or to make regulations regarding technology risks and regarding the safe and sound use of technology to deliver financial services and to protect data. So very, very broad, giving themselves very broad powers to issue specific directions to financial institutions or to issue regulations. And the interesting thing is that these directions and regulations can be issued to any quote-unquote financial institution, and the term is defined in the Financial Services and Markets Bill to also include exempted persons. So say if you are carrying on business under the Securities and Futures Act and you are exempted because you're able to rely on an exemption, that is potentially also caught. You are caught as a financial institution, and the MES can issue you with directions to comply with certain requirements. The other interesting thing to note is that the new power also extends to systems, regardless of whether they are critical systems and regardless of whether the systems directly support regulated activities. So the TRM guidelines appear to be quite broad already, and they talk generally about IT infrastructure. But the significance of this is that this new power will basically give MES the ability to make the requirement legally binding. So they could issue a set of regulations and it would be legally binding and not merely in a set of guidelines. So that's the first new thing, this new consolidated power. The second new thing is what you see here, the new maximum penalty of 1 million. The MES said they have looked at other types of similar legislation, like the Telecommunications Act, like the Personal Data Protection Act, and they've looked at comparable penalty regimes, and they feel that 1 million is the right approach, even though the industry has said that this is the penalty is really quite high. But they have said this is really important to highlight how significant tech risk management really is. Again, they said, don't worry, we may not necessarily just go straight to 1 million. We may also take other types of enforcement action. So they could issue reminders, they could issue supervisory warnings or reprimands, and not necessarily go straight to $1 million in penalties. So there was an interesting question that the industry had raised. They said, well, isn't this a bit worrying for the industry? What if I have a single data breach incident? Does it mean that I would now have multiple authorities imposing penalties under different legislation? Because you could be breaching the Personal Data Protection Act, you could be breaching the Cybersecurity Act, and now this new Financial Services and Markets Act. And MES said, in that kind of situation, they will work with all the other agencies, so the PDPC and the Attorney General Chambers, just to make sure that an appropriate course of action is taken, so you don't necessarily get penalized or over penalized, and there wouldn't be overlapping actions. So that's the implication. That's what they seem to be hinting at. Of course, it always depends on the facts. So the last point to note is just that the MES plans to issue the notices, and because these are existing notices, the notice on tech risk management and the cyber hygiene notice, they will issue it and it will be effective right away. There wouldn't be any kind of grace period before this 1 million penalty and this new power would kick in. So does anyone, before we move on to the last bit, does anyone have any comments on the new tech risk management penalty or other thoughts? Okay, I see a question here actually before we move on to the last bit. A question has been asked about how have the cross-border issues been addressed? I think this was perhaps with respect to the earlier point that we're talking about just now about POs and POs being able to be addressed to foreign services providers as well, who are based overseas. So I think this point was actually raised to the MES, and they actually said, they said, yes, we can potentially issue a PO to an overseas service provider, but they also recognize, practically, how do you really enforce if somebody is outside Singapore? So they then said, that's fine, they recognize that, but nevertheless, what this would practically mean is that if there is a PO against an overseas service provider, if the Singapore institution still uses them, then it's an offense for the Singapore institution. So in a way, they indirectly would be able to enforce and make sure that this overseas service provider cannot enter the Singapore market.
There's also another question, Pei, how TRM would apply to decentralized business models where there are no central points of failure.
You want to take that, Nizam?
I think it's a highly technical question. I would think that some parts of the TRM guidelines still apply, but we're not talking about the TRM guidelines at this webinar. We're really talking about the new powers the MES has to impose fines. I think practically what this means is you need to look at your TRM compliance a lot more seriously, right? It's beyond just looking at the guidelines and doing that Excel spreadsheet of saying which bits apply to you and which one don't, because now there's real teeth behind the the whole TRM expectations of the MES. I think given the way that risk has shifted to technology risk, I think it's not surprising the MES has taken a firmer stance on this. And okay, just to juxtapose things as well, I think when you talk about for exchanges in particular, remember we have this customer asset protection regime that's coming up under the PS Amendment Act. So you need to look at how you custodize your DPTs. So all that I think is taken in the same spirit of things, that the whole importance of protecting customer assets and putting in place the whole technology framework around it to strengthen it. That will be, I think, an increasing area of focus going forward. Sorry, Payne, please.
Oh, no, thank you. That's very useful. Okay, I think we can cover the last bit really very quickly, which is in relation to new statutory protection that will be provided to individuals in a dispute resolution scheme. So currently the MES requires certain financial institutions. So far we checked yesterday, there was no payments firm, it appears, at the moment. But generally speaking, FIs that serve retail customers under specific legislation like the Banking Act or the Securities and Futures Act, they need to subscribe as members of an approved dispute resolution scheme. So at the moment, the only one that exists in Singapore is FIDREC, or the Financial Industry Disputes Resolution Centre Limited. That's the existing one in Singapore. The objective is to provide consumers with an independent and affordable venue to resolve disputes with their FIs. There are some conditions that apply. Basically, the MES has proposed to strengthen the confidence and autonomy of the operators, mediators, educators, and employees when they carry out their duties. And MES said, let's give all these individuals statutory protection from liability. And this amendment would bring the level of protection more in line with that of other public dispute resolution bodies. So I think it's not controversial, and industry participants are generally supportive of that. Essentially, these individuals must act with reasonable care and in good faith, and the protection wouldn't extend to acts involving willful misconduct, negligence, fraud, or corruption. So that brings us to some concluding thoughts and Q&A. The FSM bill has been widely anticipated because, as Nizam said, we were all expecting it to kind of come up because of the alignment with the Financial Action Task Force standards. But as we know, the MES doesn't necessarily just apply the Financial Action Task Force standards. They sometimes go one step further. They call it FATF Plus in some cases. So in terms of when exactly the bill will take effect, I think we're going to expect some time. Is anybody's guess when exactly it will take effect? Potentially in the course of this year. So once the bill takes effect, remember there's no transition period, so it's quite significant. So it does mean that if you are a virtual asset services provider and you're providing services outside of Singapore, but you're based here, you will need to actually stop business. That's what the MES actually said specifically. You need to stop business and only operate when you have obtained a license. And then the other key point, which we discussed just now, is to note that for institutions with outsourcing arrangements, you now need to check, so kind of take an additional step to check that your employees, as well as the employees of the service providers, are not prohibited persons. And remember, the type of persons you need to actually check on also has been expanded, because you now have additional functions such as those who handle funds, those in risk management will all potentially need to be checked on, because they could be the subject of a prohibition order. So that brings us to an end. Of course, I'm going to open it up to panel to kind of comment on any kind of concluding thoughts.
Or any questions from the audience, that lingering questions that you want to ask? I think, well, I mean, if we can keep the conversation going, so if you have any other further thoughts after this seminar, you can just email the BS Secretariat, and we will, follow up with your questions. Any final thoughts from the panel members? If not, I hand you back to Kevin. Kevin?
Yeah, sorry, maybe Nizam, it's a good idea to remind about the what you call it, the topics that we are going to bring up to MAS for those people who still hasn't responded to the emails.
Yes, so I think for the BAS members, I think we are going to arrange for a dialogue with the MAS on a few things, and I think there was an email going out to members about their inputs on what they think the priorities should be, because there is quite a long list, and of course we want to prioritize the areas. I think we've gotten a few responses, but I think the numbers aren't big, and it'll be great if you can come back with us on your feedback on that. So, for instance, there were some of the topics that were identified included things like the advertising and promotion circular. It could actually, this was one of the issues that was also talked about. So the PS Amendment Act is another issue. I mean, of course, there are some other pain points like licensing. I think it's still not where we think it should be. It's quite painful, to be honest. So please respond and give us your feedback. Okay, there's a last question, I think. When will the bill take effect? Short response is we don't know. Like we mentioned in the earlier part of the webinar, it will be passed by Parliament. I think invariably in Singapore, that's just how it is. It will be passed by Parliament probably in a couple of months' time, but it could take maybe a few more months. It could even take a year before it gets implemented. So we have to wait for further announcements from the MES before on the implementation date of the Act. Okay. Any other final thoughts? If not, thank you very much for your time, your questions, and your attention.
Yeah, thanks everybody.
Sorry, there's one more question. Will today's slides be shared with the attendees? The answer is yes, if you request for it. So please let the Secretariat know if you're interested in the slides. But I think typically we also put up this session as on the BAS's social media sites, so you can look out for it if you miss us and you want to hear our voices again. So
Nizam, I think there is someone who's raised his hand.
Oh, somebody raised a hand. Can you just put your questions in the Q&A? I think we can see it quite easily. So we answered the recording bit. So I think any other final thoughts? Okay, if not, Kevin, any final words from you?
Yeah, I guess I think this has been a very fruitful session. This is evolving, right? I mean, even though that things are not exactly so-called cast in stone, but it is an evolving space. As usual, being part of BAS, we are always gathering feedback that we want to converse with MS about. These are all very good questions they ask, and obviously that always form as part of the feedback session we have with MES. Yeah, so I think that's probably our end. Yeah.
Okay.
Again, this is recorded. So I think we will share the recording when we can. Thank you.
Right. Bye and stay safe, everybody. Thanks.
Thanks, everyone.